Alice. I live on Night Island also off of the Indian Acres property. And if indeed your definition of hardship is that you had to own this property prior to the 8th of December, November of 2008, why are people who are able to own a second piece of property now considered a hardship and should be able to live there full time? If I could not afford my second home, what would I sell? I would sell my second home. It's a no-brainer.
Thank you.
Good evening, distinguished members of the board. My name is Denise Taylor. I do not reside in Indian Acres, but I do co-own a farmstead there. I visit it often, and especially more now since I'm retired. I have no objection to those owners who have chosen to reside in Indian Acres, but the issues that are being discussed tonight affect my rights as a property owner, in that the letter of intent, if signed by the parties, will enforce against me, as well as the other property owners, a zoning ordinance that is not applicable to us, or, as applied, represents an unconstitutional taking. I will leave that discussion for the court, should that action be necessary. Although the Intermediate Appellate Court, in an unpublished declaratory judgment ruling limited to the plaintiffs in that case, affirmed that Indian Acres is campground within the meaning of the ordinance, it failed to determine if the application of the words patron and maintain were properly applied to the plaintiffs and their property. If we look at the plain meaning of section 101.15, which we must do, which reads that no camp patron shall be permitted to maintain or use the camping site or facilities at any camp or campground, and then the controversial language, including the 100 or 150-day language, the words patron and maintain must be given their plain and ordinary meaning. Patron is defined as a paying guest. Certainly the owners of the property at Indian Acres are not paying guests. Maintain is defined as to keep in existence. Certainly we can maintain property that we own. Owners of farmsteads in Indian Acres cannot be construed to come within the meaning of either of these words. Even Indian Acres must have not thought that this applied to farmstead owners, as they specifically distinguish between campsites and farmsteads. Further, the covenants, Article 7A1, state only that no farmstead shall be used as a residence or anything but camping purposes. Nothing in there limits the days which an owner can visit their own property. These restrictions were not amended in 1993 or 2007. When the board put in effect the definition of a campground, including the 150-day limitation. Surely Indian Acres did purposely misrepresent the property in their sales practices. Section 8 of the letter of intent, although it may not have set out to do so, imposes an obligation on Indian Acres to restrict access to owners of farmsteads that do not reside in the community and have not entered into this consent agreement, whereby depriving them of the privileges extended to those members that are in violation of the covenants. In addition, the letter of intent and the consent order between the parties constitutes illegal, conditional, or contract zoning, not authorized in Article 66B, 401B, which constitutes the totality of the authority of the grant of power to this board. The statute says nothing about utilizing conditions to limit or expand uses, and therefore grants no such power. Furthermore, zoning authorities are not permitted to enter contracts that inhibit the proper exercises of the municipality's governmental powers. Section 402 requires uniformity within a class or development in a district. Hence, it necessarily prohibits conditional use or contract zoning. Allowing such would fly directly in the face of this section and the mandated uniformity. In addition, the language in the grant of the power to the board referring to restrictions, conditions, and limitations applies only to the structural and architectural character of the land and the improvements thereon. Restrictions, conditions, and limitations on use are neither explicitly provided for in the subsection, nor can they be applied therefrom. This interpretation has been adopted by our highest court in the case of Mayor and Council of Rockville versus Rylands, 373 Maryland 514. I would ask that you consider the limitations of the power granted to you by Article 66B, along with the effects that your actions will have on the owners of the farmsteads located in Indian Acres, and further litigation is sure to follow unfair treatment. Thank you.
Good, thank you.
Yes, I'm a homeowner also there, and I visit there on the weekend. And
Your name, please. Your name.
Diane Muskimen. You really do not have the authority to make the decision that you're about to do, and as previously stated, further litigation is going to pursue this. Thank you.
Mr. President and members of the board, my name is Cassie Heron and I'm the Sassafras River Keeper. Thank you for the opportunity to speak in regards to Indian Acres tonight.
Could we get could everyone please give their addresses as well as their names, please, for the record? Thank you.
Sure. Cassie Heron, and it's P.O. Box 333, Georgetown. As a representative of an organization with a mission to protect water quality in the Sassafras watershed, and as a citizen born and raised in Cecil County, I'm baffled and strongly oppose the current letter of intent regarding Indian Acres, as it does nothing to address water quality issues. The current letter omits any requirement of a sanitary review for residents entering the proposed transitional program, and it fails to address any of the unsettling environmental and health issues that we have discovered that violate current county code. For instance, reported incidents of waste and gray water dumping directly on the grounds. While the health department follows up on these reports, there has not been one violator held accountable for this illegal activity, and there are at least 8 open cases that have yet to be resolved. There are 12 parcels with sewage lines directly connected to one of the larger community septic systems, as referenced by the owner of Indian Acres. County law states that no sewage system may be constructed by a private owner without prior approval of the Director of Sanitary Facilities, yet the Cecil County Health Department had no prior knowledge of these systems until we informed them today. And finally, permits are currently issued to allow individual septic haulers to pump sewage from Funstead owner holding tanks and discharge that sewage into one of the combined septic system in Indian Acres. But county ordinance states that all Cecil County septic must be discharged at a septic receiving facility at the county landfill, and all waste must be accompanied by a completed waste manifest form. But for some reason, septic haulers are permitted to operate within Indian Acres and not required to keep a manifest or any record of pumped sewage. While the Sassafras River Association supports enforcement of county zoning, our concerns transcend the issue of residency. Whether full-time or part-time, no attention given to environmental and health impacts is irresponsible and apparently illegal. That said, a 10-year transition from part to full-time residency would only exacerbate the issues I've raised. Thank you.